Okay, people. So now it is February 27th, 2019. Going through papers. 1 in 5 organ donors connected to fentanyl. This is in British Columbia, Canada. A total of 19% of deceased, already died, people. Donors have deadly synthetic narcotics in their system when they arrive at hospital. 1 in 5 deceased organ donors in BC last year had the deadly synthetic. 1 in 5 organ donors had the deadly synthetic narcotic fentanyl. You can add ShaMay into that number, which is not accounted for, people. Okay? Anyway, as you can see, what I'm doing here, I am just now going through paperwork. This is what I've done here. You can see, right? I've listed everything with the little sticky papers that, you know, right? Story of my life. And then, but before we carry on, I'm just doing some catch up here. Right? In terms of documents. All right.
I'm alright.
They tried to say ShaMay was shivering. She wasn't shivering, people. Okay. This was dated February 21st of 2018. It was written this day, February 20th of 2018. They like to choose my birthday. All right, because they want to insult me. Memorandum of Argument of the Respondent, Fraser Health Authority. Overview. Okay, this is the Court of Appeal. This is what they put in front of that judge for waiver of fees. Hold on a minute. Okay, this is waiver of fees, no application, right? For waiver of fees. That's what it was, a no fee application. I went in February 28th, 2018, in front of a judge who sent me to the cops. But this is what Fraser Health Authority put in to prevent me from having my fees waived. And this is a memorandum by them, right? The appellant. That's me. Application seeks no fee status. The respondent opposes the appellant's application for no fee status on the basis that the appeal lacks merit. Haven't we heard that before, people? The intended appeal arises from the order of Mr. Justice Bowden, made on December 7, 2017, striking the appellant's pleadings and dismissing the appellant's claim against the respondent. The applicant has not yet brought her appeal, is out of time to do so. I was told I couldn't bring my appeal forward until I had my application of fees waived. And you know I wrote those 7 pages and brought it down to 3.5 pages. Is out of time to do so and will need to bring a separate application to seek an extension of time. Did I read this? Facts. On February 17, 2017, the applicant filed a notice of civil claim in the Supreme Court of British Columbia, totaling 175 pages. The claim related to health care rendered to Mr. John Duncan, while Mr. Duncan was admitted at facilities operated by the respondent between January and February of 2015. Mr. Duncan was not party to the action. Well, he couldn't be, people. He disappeared. He was medically kidnapped. He was drugged up with OxyContin. He was denied access to his family members. He couldn't appear, people. And then we've got the affidavit, which is one of those big binders. On September 15, 2017, pursuant to a case planning order, the applicant amended the claim to condense it to 20 pages. On December 7, 2017, Mr. Justice Bowden heard the respondent's application to dismiss the claim. The respondent applied to the notice of application to inter alia, I don't know what that means, have the amended claim struck in its entirety pursuant to Rule 9.5 of the Supreme Court Civil Rules. And then there's another affidavit. Mr. Justin Bowden, on hearing counsel for the respondent as well as the appellant for herself, speaking on behalf of Mr. Duncan and the rest of his immediate family, ascended to the respondent's application and ordered that the whole of the plaintiff's amended claim be struck out and the proceedings dismissed. Based on case law, people, that had nothing related to Uncle John. They skirted the Criminal Code of Canada, and they skirted all the provincial laws within the province of British Columbia, Canada. Mr. Justice Bolden held that it was plain and obvious. Anything plain or obvious should be on the table. But they're burying it, people. Right? And obvious that the claim was bound to fail. There was nothing obvious that the claim was bound to fail other than they used the court against me and the fact that I was pushed into dire poverty, already living in poverty, but really over the edge, right? With depressed kids, depressed grandchild, depressed herself, you know, as we're being gang stalked on various levels with energy weapons going through my yard. And like I said, when I put in my notice of claim for ShaMay, I'm going to make sure that those videos are included and it's written down into the notice of claim that something is going through my yard. I have it documented, and not only through my yard, but in my house, that could very well be affecting people's health, or mental health for that matter. And, I mean, it's obvious. We're targeted. ShaMay was targeted. Uncle John was targeted. You could almost say Amari's being targeted, right, with botched MRIs and 50 pokes later with one blood test. Mr. Justice Bolden held that to the extent that the claim alleged wrongs to Mr. John Duncan by Fraser Health Authority, Ms. Chorney has no standing to bring the action on Mr. Duncan's behalf. Well, yeah, because I guess Eleanor has to do it, but Eleanor's never going to do it because Eleanor is the one who harmed and injured him, right along with Fraser Health Authority, right? And if she got away with it with Uncle John, she's going to do it to other people. And if she's not going to do it to other people, she's going to train other people how to do it. And they will use those laws and those regulations, right, to their advantage. And then when they break them, they won't acknowledge them because they'll hide behind the court rules and crooked judges and crooked lawyers to bypass the whole story by bringing in somebody else's story that has no relation to Uncle John in any manner, in any capacity. Further, to the extent that Miss Chorney claimed wrong on behalf following from the care provided to Mr. Duncan, Fraser Health Authority had no duty to Miss Chorney as she was not a patient of the Health Authority. Again, they have made sure that I can never be a patient to their Health Authority people because this is how they treat their patients. I was speaking on behalf of Uncle John, the kids, Andre, who is his grandchild, great-great-grandchild to Uncle John, who never did have his own biological children because his wife was bulimic and anorexic, right? So he adopted his own family. No evidence was presented. This is what I wrote. no evidence was presented for lack of a trial. They can't assume anything unless they have a trial, so that the evidence can be presented to in front of a court. Mr. Justice Bowden was not a trial judge, but rather a dismissal judge who made his decision within less than 30 minutes. Kind of like that pro bono lawyer. Argued with me for 15 minutes, told me I needed to go sue Eleanor, go take it to the wolves, so they can just hide behind court rules, crooked lawyers and crooked judges, right? As people are losing their body parts as they're going into the emergency room through the back door when they should be pronounced dead in their homes and deemed suspicious. Further, to the extent that Miss Chorney was not a patient, 30 minutes, Justice Bowden did not review all the evidence because it was a 30-minute little trial. Right there with 100 people standing there watching. And had no interest to do so. Because he was bought off. He was told to throw it out. Rule 56 of the Court of Appeal rules sets out the test for indigenous status as follows. Indigenous litigations. Despite anything in these rules, no fee is payable to the government by a person to commence, defend, or continue an appeal or application if a justice on application before or after the commencement of the appeal or application finds that the person is indigenous unless the justice considers that the position being argued by that person lacks merit. Full circle, people, is scandalous, frivolous, and vexatious. Again, they're insulting you. So they're not only insulting you in the Supreme Court of Canada, but now they're insulting you at the appeal court before you even get to go and stand in front of a real fucking judge. In otherwise, an abusive process of the court. 8 lives have been ruined. FHA is misleading the court and acting in bad faith. Criminal Code of Canada lacks merit? Is that what they're saying? There are 2 factors that must be examined in determining whether indigenous status holds should be granted. 1, the likelihood of success of an appeal. So if you're not guaranteed to win your appeal, then there is no point in trying. That is what he's basically saying. The likelihood of success.
The big one too.
Hold on a minute. Okay, so unless the justice considers that the position being argued by that person lacks merit, so they consider the Criminal Code of Canada and all the provincial laws in the province of British Columbia, Canada, to lack merit, is scandalous, frivolous, and vexatious. Okay, 8 lives have been ruined. FHA is misleading the court and acting in bad faith, is otherwise an abuse of the process of the court. 2, there are 2 factors that must be examined in determining whether indigenous status should be granted. The likelihood of success of the appeal. So they've already deemed it guilty, right? They've prosecuted you, and now they've jailed you for the 3rd time. Okay? And the financial position of the applicant. They didn't even look at the financial position of the applicant because they wouldn't take any of my papers. 3, indigenous status will not be granted in appeals that are bound to fail. There we go back to that case law. See, there's the case law, okay? This is all case law that they're using. They're not using Uncle John's case. They're not using Uncle John's story. They're using somebody else's story. There are 2 factors. Indigenous status will not be granted in appeals that are bound to fail or where there is no reasonable basis for an appeal. If an appeal, now you see, this is why CIBC Bank is protecting Fraser Health Authority, because it was CIBC Bank that didn't protect Uncle John from having predators come into his account and then taking over his account as they took over his life and destroyed his life while they did it so they could take money that he didn't know anything about for 14 months and then put it into some shadow account so they could steal it. Bank didn't care as long as it was getting its interest. That's all it cared about, people. There's fees to all that. Those transactions. The overriding consideration, so a 20-minute dismissal. A 20-minute dismissal hearing cannot determine what will fail, and nor can case law, and nor case law. You can't have a 20-minute dismissal hearing with a biased judge, right, that's coming in biased before he even sits down, and then have it determined that it's going to be failed by that biased judge, and base it all on case law, as it's purposely ignoring federal and provincial laws, and it's doing it through court rules. The overriding consideration when assessing whether indigenous status ought to be granted is the interest of justice. Where's the justice for Uncle John? Where is the justice for ShaMay? Where is the justice for Amari, Alea May, and Andre? Where is the justice for Uncle John's grandkids? Brooke, Sierra, Marcane, Tisha. Well, we know what happened to ShaMay now, don't we, people? You think there's going to be justice for ShaMay when this stuff goes to court with ShaMay? Do you honestly think that they're going to admit that there's illegal organ harvesting going on if they can't even admit to this? Like, really, where was the money being transferred around when ShaMay's heart organs, valves, when the heart valves and other ligaments and tissues that were taken out of her body? Where did that suitcase of money go? I'd like to know. Is it being bought with fentanyl money in a suitcase, people? That's being run through the freaking casinos in the province of British Columbia, Canada? As the cops stand by and just keep an eye on things and make sure the boat doesn't get rocked? The overriding, interest of justice. Ignoring infractions under the Criminal Code of Canada or legislated provincial acts and regulations is not in the interest of justice. Ignoring what I put on the table here is not in the interest of justice, people. The appeal lacks merit. The order granted by Mr. Justice Bowden was rendered pursuant to Rule 595 of the Supreme Court Civil Rules and was discretionary. So, discretionary, what does that mean? Maybe so, maybe not. In nature. Rule 95 affords the Supreme Court the discretion to strike out the whole. So maybe she has a point, but it doesn't really matter because I've already been bought off before I put my fucking robe on. So I'm just going to go do my job as my master tells me to do. Strike it out. Rule 95 affords the Supreme Court the discretion to strike out the whole or any part of the pleading, if it discloses no reasonable claim. Again, you don't get to show your evidence. You don't get to cross-reference anything. You don't get acknowledged. On the contrary, you get insulted. Is unnecessary, scandalous, frivolous, or vexatious, if it may prejudice, embarrass, or delay a fair trial or hearing. And then they make it sound like they're going to give you a fair trial or a hearing, but of course that's never was on the agenda. Or if it was otherwise an abusive process. I'm a sick woman, people, with no money, and I'm abusing the court. Okay. Get that one. Look at this. Look what came in the mail for ShaMay today. If she was working, this wouldn't have been an issue for her. Right? She could have qualified for $7,500 credit card. But she's not here anymore, people. She belongs in this pile of shit. That's where ShaMay is. In that pile of shit right there. Justice Bowden had falsified court transcripts. So we got a judge being discretionary without looking at all the evidence because he's simply following what somebody told him to do, falsifying his own records, right? And this is supposed to support Fraser Health Authority with their denying me access to waive my fees so that I can go in front of a 3-panel judge and have him look at it and decide whether it should go to trial. A discretionary judge ought to be afforded a high degree of deference from appellate courts. An appellate, okay, this is case law again, people. This is case law telling that judge that called the sheriff on me what to do. To avoid talking about what we were there for, outside of no fee application. An appellate court may interfere with the discretionary decision only when the judge failed to give weight to all relevant consideration or commitment, an error or principle. So in other words, Mr. Bowden there, Justice Bowden, he really put a lot of thought into it before I showed up. So much so that he was determined to dismiss it even before I had opened my mouth. But he gave me 15 minutes to explain well, maybe 10, as he insulted me along the way, right, to explain myself, and then just came down with the gravel and said, no, that's it, because I gave it, hours and hours and hours and hours and hours of thought, even though it worked out to milliseconds and seconds and a few minutes. Justice Bowden did not review all the evidence and sat as a dismissal judge to just do that. So we got judges being paid just to dismiss things, okay? As they use the case law that's unrelated to anything that you're putting on the table as the excuse to do it. Accordingly, the appeal is bound to fail. Again, you've been prosecuted, deemed guilty, right? Judged, right? And then now you're going to jail. And has no likelihood of success. In the circumstances, it is unnecessary for the court to consider the application's financial situation. And then that's when they came in with that little green book. Remember, I was told first 7 pages, then 3. I brought it down to 3.5, and then I was told I couldn't even bring in the 3.5, or anything for that matter, because it was just an appeal process in terms of, not an appeal process, a waiver of fees, right? And, but Andrew came in with that and that on that day with that judge. And I wasn't even allowed to submit 3.5 pages, people. Okay? Where is it? It's in here somewhere. Where's my 3.5 pages? See, everything starts to look the same after a while. Anyway, you get the point. 3.5 pages. The judge wouldn't take it. I had to plead with him to take it. And then he left and he read it, the 3.5 pages or whatever the fuck it was. It was 3.5 pages. And then he came back and that's when he said send it to the cops. But Andrew came in with all that. And the judge freely took it. Whereas I had to plead for him to take those 3.5 pages. And now I'm being accused of abandoning this. Because they want to throw it out of court that way now. After my daughter's been murdered. Her body's been desecrated. I can prove it, people. I've already put one picture on one video. I'll put the same picture on this video. You'll see it at the end. Nothing normal about what you will see. Like I said, she wasn't shivering, people. My daughter was not shivering. In the hospital, that is. Dead people don't shiver. There was no trial, rather a punishment handed down. This is number 6. Rule 9.5 affords the Supreme Court the discretion. Okay, read that. Already read that. Mr. Justice Bowden exercised the discretion when appropriate and reasoned. No error of principle was made, right? So he sided with Master Taylor. Actually, he didn't side with anybody. He just made his own decision because it went from Master Taylor to Justice Bowden to the judge who sent me to the cops. 3 judges. That was it, people. So he took a 15-minute fucking little mini trial in a room full of 100 people and decided that whatever I had to say was frivolous, vexatious, and lacked merit, right? Because they didn't want to look at the Criminal Code of Canada. They didn't want to look at the legislative laws of the province of British Columbia, Canada. They just wanted to use court rules against a poor person that is being targeted through the public union sector as their family members are either disappearing or dying one by one. This just happened in April of 2018. Very, very recent, people. It is unclear on what grounds the appellant intends to pursue this appeal. The appellant fails to point to an error of law or misrepresentation of facts. The respondent should not have to speculate as to what the appellant may be referring to. And again, case law. This is case law. The appellant so they base their reasons on case law. Nothing about what happened to Uncle John. Nothing. Absolutely nothing. You know, for all these old farts sitting around in these fucking chambers, I'd like to see some of them go through what Uncle John went through. Honest to God. Maybe if a couple of those dudes went through that shit when they get real old. But you know what? Those are the ones that are buying the organs, people. Because they can afford it. They're the ones with the portfolios and want to live forever. So when it comes time to take ShaMay's shit to court, nobody's going to listen to it. Right? They're going to play the same game. Case law. Accordingly, the appeal is bound to fail and has no likelihood of success. In the circumstances, it is unnecessary for court to consider the appellant's financial situation. Conclusion. The appellant has the onus of proving that she has met the threshold test for indigent status. They never even let me put my application forward, people. They didn't look at anything when it related to my financial circumstances when it comes to asking for a waiver of fees when you're dealing with a court. They didn't even look at it, people. Andrew passed over his shit. Judge called the frickin' sheriff on me when I started citing the Criminal Code of Canada and the legislated acts. And then he graciously took 3.5 pages after I pleaded with him to at least read them. And then he sent me to the cops, and I just haven't been back yet. Because soon after that, ShaMay was murdered. The test cannot be met as the appeal has no merit. They've prosecuted you, they've made judgment on you, and they've jailed you. Accordingly, the motion should be dismissed, all of which is respectively submitted. So, anyway, there you go.